I'm attorney Hal Davis. I represent injured workers in Utah. If you are hurt at work, you can save yourself a lot of hassle by avoiding these 4 big mistakes. These 4 mistakes usually result in delayed or denied benefits and make it more difficult for your attorney to win your case. Mistake 1: waiting too long to report your injury. Utah law allows you 180 days to report an injury or illness to your employer that is caused by your work. The clock starts ticking on the date you know, or should have known, that your illness or injury is work-related. The sooner you report your injury to your employer, the better. Sadly, some people wait too long because they're afraid of being reprimanded or losing their job, or because they think their injury will heal up on its own over time. The longer you delay reporting your injury to your employer, the more suspicious the work comp carrier will consider your claim. Mistake 2: not telling the doctor what really happened. Tell every doctor what really happened. Don't let an employer talk you into being dishonest. Some employers ask injured workers not to report the accident and then promise to pay for medical treatment outside of the workers' compensation system. This is a huge red flag. It means that the employer doesn't have workers' comp insurance, is trying to cover up a bad safety record, or doesn't want to pay full medical, lost wage, or permanent impairment benefits. Always be honest when reporting your injury. If you aren't, the insurance company or its attorney will try to paint you as a liar later on. Mistake 3: not cooperating with your adjuster. Cooperate with the adjuster when your insurance company requests that you disclose your medical care providers and that you sign HIPAA medical releases. These are common and allow the work comp carrier to obtain your medical records for the workers' compensation claim. Utah law requires that the injured workers disclose 10 years of medical providers, whether they have treated the body part injured at work or not. If you claim that you will never work again because of your injury, 15 years of medical providers must be disclosed. Medical providers include hospitals, clinics, doctors, chiropractors, and physical therapists, excluding providers of gynecology or mental health services, unless your injury at work involves them. Mistake 4: quitting your job. Sometimes employers will pressure an injured worker to quit a job by making the work environment unpleasant or by asking them to resign. If you voluntarily quit your job, it means workers' comp doesn't have to pay you any kind of lost wages. On the other hand, if your doctor has placed you on light-duty work restrictions and your employer fires you, workers' comp must pay you lost wages until you are released back to full-duty work by the doctor or until you get another job. If you're on light-duty work restrictions, and if your employer has a light-duty job for you to do, you must perform the light-duty job in order to keep receiving wages. If your employer ignores your doctor's light-duty restrictions, call an attorney, but don't quit. Avoiding these 4 big mistakes will help you get your workers' comp benefits with minimal hassle.